Madam Registrar, could you please call the case?
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, judgment delivery in CCJ Civil Appeal, GYCV number 12 of 2019, between Shri Affron Nabi, Rafael Nabi, the estate of Shri Amin Nabi, and Ashmidphiraque Sheermohamed, S.A. Nabi and Sons Limited, and Maurice Solomon. Today's panel comprised the honors Mr. Justice Witt, presiding judge.
Good morning, counsel.
Mr. Justice Anderson.
Good morning, counsel.
Mr. Justice Barrow.
Good morning, counsel.
And Mr. Justice Burgess.
Good morning, counsel.
May we have your appearances, please, counsel?
May it please the court, Devendra Kissoon on behalf of the appellants Shir Affron Nabi, Rafael Nabi, and the estate of Shir Amin Nabi.
May it please the court, William Hare and Miguel Vasquez for the respondents, and I convey the apologies of Christopher Parker QC, but for the hand-down of judgment, he's not going to attend today.
Okay, thank you very much. In the judgment, you will find a postscriptum, which I will now turn in a pre-locutio, which is to say that the court heard this matter on the 21st of November 2019, which is a little more than 9 months ago. The delay in delivering this judgment is measured to our own standards, excessive and regrettable. And as the presiding judge of this panel and co-author of the judgment, I wish to take full responsibility for that delay, for which I offer my apologies. Then I'll turn to the judgment itself. The four judges present were mentioned. Justice Rajnath Lee is momentarily not present, but of course took part in the deliberations of this judgment, and she has signed it. I will read not the whole judgment, but a summary of the judgment, and which is not intended to be a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. On 11th of November 2009, Sheermohamed filed a petition in the High Court of Guyana seeking an order that S.A. Nabi and Sons Limited, the company, be wound up pursuant to Section 354E of the Companies Act of Guyana, on the basis that it was just and equitable to do so. The company is family-owned. Following its incorporation, the relationship between the shareholders became acrimonious. In these circumstances, Sheermohamed, the first respondent in this appeal, filed his petition in the High Court seeking the winding up order. The High Court, Justice Persaud, granted the order for the just and equitable winding up of the company on the 10th of June 2015. On the 1st of July 2015, the appellants filed an appeal against the order of Justice Persaud, the first appeal. On the 5th of February 2016, Justice Persaud refused to grant the application by summons made on the 29th of June 2015, seeking a stay or revocation of the winding up order, and appointed a receiver manager. The appellants appealed this order to the Court of Appeal on the 25th of February 2016, the second appeal. Court of Appeal held that it had jurisdiction to hear the first appeal, but that it had no jurisdiction to hear the second appeal. That appeal, however, was dismissed on the merits by the Court of Appeal on the 26th of June 2018. The appellants then appealed to this court. The notice of appeal of the 10th of April 2019 disclosed a single but amply argued ground of appeal, namely that the Court of Appeal made an error in all the circumstances of the case in upholding the exercise of discretion by Justice Persaud to grant the order for the winding up of the company. This court agrees with the Court of Appeal's finding that the just and equitable provision enables the court to subject the exercise of legal rights to equitable considerations. The court is satisfied that the Court of Appeal acted upon correct principles of law in upholding Justice Persaud's Section 35E discretion in ordering the winding up of the company on just and equitable grounds. The question which the court had to solve, therefore, became whether the Court of Appeal of Guyana misapplied these principles to the evidence before it, as contended by the appellants. This court agrees with the Court of Appeal that the clear law is that a shareholder or someone in the position of a shareholder is a contributory as defined by Section 350 of the Companies Act. The court is satisfied that there was sufficient evidence available to the Court of Appeal to hold that the first respondent was a shareholder or was in the position of a shareholder. Accordingly, the first respondent was a contributory within the meaning of Section 350 and therefore could commence the Section 354E winding up petition. The court finds that the Court of Appeal did not make an error in making findings of fact unsupported by evidence and found that in its admirably well-reasoned judgment, the Court of Appeal meticulously made its findings of fact based on the record. The court also finds that the Court of Appeal did not misapply the just and equitable principles and that there was an abundance of evidence to support the finding that the parties were in deadlock. The court found that this was as clear a case of company deadlock as can be imagined. The general decision-making process within the company had broken down. There was no realistic prospect of it being repaired. The court also found that this was not an appropriate case. This is not an appropriate case to order a buyout of the company's shares, as there can be no order for a buyout where there is such profound uncertainty about the subject matter of the buyout, which is the number of shares to be bought. Finally, the court finds that the equitable maxim, he who comes to equity must come with clean hands, an old maxim in this time of pandemic, maybe a very clear maxim. He who comes to equity must come with clean hands applies to the exercise of the Section 35E, just and equitable winding up jurisdiction. The court disagreed with the Court of Appeal's reason for rejecting the appellant's unclear hands argument. The court feels bound to emphasize that the Court of Appeal should have considered only the hands of the first respondent and that there was no need to balance the misconduct of the first respondent against that of the appellants. For the foregoing reasons, and they have been summarized very briefly, for the foregoing reasons, the court will make the following orders. A, the appeal is dismissed and the judgment of the Court of Appeal is affirmed. B, the appellants shall pay to the respondents costs of this appeal, certified to be taxed in default of agreement. This is the judgment of the court. Is there anything unclear?
No, Your Honor. Much obliged. On our way.
My Lord, could I, with the court's permission, address the court very briefly in relation to the costs
Yes.
order which you've just made? And I just want to say three things. And before I do say those three things, I'd first of all like, obviously, to thank the court, all the court, and present and not present, for their kind consideration of this decision. And as obviously, it's very difficult for lawyers and judges over the last few months, and we fully appreciate the difficulties that have been imposed on everybody. In relation to the question of costs, I think there are three points I wonder if the court could consider briefly. The first is that whether the costs that are in the draft order are for the costs here, but in my respectful submission, given that there are costs orders below the taxation process, it would make sense and be a sensible use of everyone's resources that the taxation process include costs here and below. In other words, in the Court of Appeal and at the High Court, because that would be, it can all be done in one go, and the registrar can just deal with one group of costs. And we're not dealing with two separate cost assessments, one in the Guyana High Court, possibly one separate one in the Guyana Court of Appeal. They can all be done here, obviously on the Guyana basis in relation to the lower two courts. But in my respectful submission, that's a sensible resource where there's a sensible allocation of resources where the costs orders have all followed the event. That's my first point. My second point is I would be grateful, having regard to the 2019 appellate rules of the CCJ, and in particular Rule 18.6, I would be grateful for the court's certificate that this appeal was suitable for three counsel. And having regard to, this is in relation to 18.16, where the court is obliged to look at, or the registrar is obliged to look at the matters in 1810. This court has obviously heard the appeal, but it can in its order certify, having regard to 1810 E and H in particular, that the matter is of such complexity that it's suitable, one, for three counsel, and two, for specialist leading counsel. Obviously, you heard Mr. Parker give the presentation on behalf of the respondents. So that's the second point I would ask. And the third, my third request is, given that there's been a very large expense, none of which has been borne by the appellants to date, I would ask for an interim order pursuant to 18.4 subparagraph 6, an interim order for costs. I'm in the court's hand as to the quantum of that, but there have been two very long hearings in Guyana, and there's been an appeal in Trinidad to which leading counsel and senior junior counsel have flown from off island, and obviously Mr. Vasquez has appeared in Trinidad. And in my respectful submission, the costs are plainly going to be very substantial when they are taxed. And I would ask for an interim order under 18.4, and conservatively, I would ask for $100,000 US, and if in the alternative, such sum as the court thinks appropriate. So those are the three things. To recap: first of all, costs here and below, in the courts below, to go to the taxation, to the registrar. Second, certificate suitable for three counsel and leading counsel. And third, the interim order for costs. I can expand on any of those if you'd like me to, but it can get quite weighty, and perhaps those are best if you're with me in relation to that. I would save everything else for the registrar.
Yes, you said three counsel and a specialist leading counsel.
No, three counsel, including specialist.
Including.
Leading.
Okay, including.
There were three counsel in attendance on the appeal.
Yeah, to be clear, and an interim order for costs.
An interim order for costs. We say that they're plainly going to be very significant. I don't have the figures for below, but we know that there were lengthy hearings. The proceedings have been ongoing since 2009. There were trials with witnesses at which the appellants lost. They've not paid a bean in costs to date.
Okay, Mr. Kissoon.
Your Honor, we would like an opportunity to address these issues to the extent the court wants to entertain them in writing. But in précis for the first matter concerning the issue of costs, in the lower courts, both courts assessed costs, and those costs are fixed and remain as they are. in dealing with the issue of costs being certified fit for 4 counsel, it appears, I simply would draw the court's attention to the...
I think fit for 3 counsel, as I understand it.
One
of which is a leading specialist.
Certainly, Your Honor, then forgive me for that misunderstanding. I simply would like to draw the court to its recent approach in the Eslin David matter, where there were a myriad of counsel dealing with very complex matters, and in those extreme and egregious circumstances, the court had only awarded costs fit for 2 counsel. And in this particular circumstance, which doesn't rise, this particular case, to the level of involvement that those cases are dealt with, we would respectfully submit the cost for 1 counsel is appropriate. With respect to the issue of interim costs, in addition to being asked an opportunity to deal with that issue in writing, should the court want to entertain it.
Counsel? Yeah, I'm sorry to interrupt. I wanted to convey a message to the president of the court to say that our brother Dennis has had a difficulty with his computer.
Oh.
It's knocked off and he's trying to get back on.
Okay.
So I don't know if we wish to give him a couple minutes to try to do that. Thank you.
Yes, we could do that. But I was thinking while you were speaking, first of all, well, Justice Barrow fell off the line, so to speak. But apart from that, Justice Rachnod-Lee is not here. So I don't think we are in a position to give judgment on those issues right now, I thought.
Mr. Chairman, I am happy to say that I'm back on the line.
Welcome back, Justice Barrow.
It was an auto shut off, not rudeness on my part, I assure you.
No, I'm sure of that.
I don't know when my lord dropped off, but I was hoping it wasn't just dropping off when in light of my submissions, and I was hoping it was in light of my learned friend submissions. But given that it was an auto shut off, perhaps that's a better explanation.
I apologize to him and not to you, since I heard you fully. Thank
you very much.
Okay, well then, summarizing, Mr. Kissoon, he. Well, in very short terms, he doesn't agree with what is suggested. But I was just about to say, well, I didn't know you dropped off. But apart from that, I was saying that Justice Rachnod-Lee, who was part of the panel, is not present. So it would be difficult to certainly, if there is no agreement on this, to take a decision right now on those issues. So I would suggest, but I will look at my colleagues too. It is quite clear what you're asking, Mr. Herr, but and I don't want to get into much written submissions again.
I don't, my lord, if you forgive me, I don't think this is on this particular order. I mean, the written submissions should go for the registrar. This is just overburdening the CCJ. The observation, the registrar is the one who makes the determination about whether. And all I'm asking for is that in the court's view, in the view of the people who actually heard this appeal, heard the issues, read the skeleton arguments, did you think it was suitable for leading counsel to address you, or do you think that, as my learned friend says, one counsel should have popped up? And obviously we haven't got the counsel from Guyana who did that, but he raised a huge amount of issues in his notice of appeal. I haven't got it in front of me, but it was compendious in the points which were raised. These are specialist issues of company law and insolvency law. They're novel in this court. They're novel in Guyana. And in my respectful submission, I can't think of a more appropriate case for leading counsel than this. And you know, he mentions a case which he says is different. I've got no idea what case he's talking about. But in my respectful submission, far more simple cases merit the attention of leading counsel than this one. And in this case, obviously, you've got the first junior counsel, which is myself. We've got a leader, and then Mr. Vasquez is local Trinidad counsel attending to matters, so his involvement in the actual arguments is fairly reduced anyway. But those are the simple points that I would make. It's not a matter where we need written submissions. I mean, the court hears it and the court can form its own view.
Yeah. But the court is not complete. That's the problem.
It may not be complete, but
yeah.
you know, there are four of you here.
Yes, there are four of us. Okay,
Mr. Chairman, I would be very happy for us to give a determination on these points at a later date.
Yeah, I think that will be better. And then
Absolutely.
we can.
I'm fine with that. I've raised them now. I don't think they need written submissions. You've got the points. You know, it's obviously going to go off to a taxation because I apprehend there's going to be no agreements on anything. But it's so that the registrar is assisted, first of all, that he can make the order to comprise whatever has been ordered below. If it's already been ordered, then there won't be anything to assess. Second, the views on the registrar, who has not heard the appeal, will form under 18.10. The court can inform the registrar by including in its order its own view on that, leading counsel and three counsel. And third, the interim order as to cost. That's something that the court can make. I'm not sure the registrar can do it. I haven't studied the procedural rules, the 2019 rules in sufficient depth, so you'll know better than me. But that's what I'm asking for.
Yeah, well, it's clear what you're asking for. So let me just give the floor to Mr. Kissoon to, at least so he can make clear why he disagrees on what grounds.
Of course. Well, Your Honor, certainly from the perspective of putting the matter before the court, we would invite the court and hopefully persuade the court that the better course, in the event that the court is minded to entertain the argument and change the judgment that's given with respect to the cost award, to, as it did in the Eslin David matter, invite both parties to make a short submission on the issue of costs. Certainly, I would respectfully ask the court for an opportunity to address the issue of interim costs. I haven't looked at the section. I'm not sure of the threshold. I'm not sure of the circumstance. I'm not sure if affidavit evidence is necessary. And I don't intend, in the Eslin David matter, the court undertook a very truncated, very simple approach for a very short submission on each side. And I would hopefully I would like to persuade the court that would be a better option in light of what has been asked by the respondents.
Mr. Chairman, I am persuaded by that argument, and I would suggest a very short number of pages, maybe a few pages in terms of submissions. I don't have a number necessarily concrete in my mind, but maybe 4 pages. You have? Okay, well, please go ahead.
3 pages.
Oh, 3 pages. Okay.
Mr. Chairman, I want to say, as usual, I'm happy to say I am on the same wavelength as your good self.
Okay, thank you.
One, and secondly, I would want to sound the caution to Mr. Kissoon that since he is bearing costs, this process will add to his costs, but it's a matter for him.
Sorry. Mr. Chairman, I too agree with my brothers that we would benefit from short submissions. Now, the whole issue of interim costs, and when interim costs are awarded, that's a matter, I think, which this court has not dealt with as yet. And I think that we could benefit from some submissions on interim costs in particular. So I would go along with a fairly concise set of submissions in respect of especially interim costs.
Okay, well, I think now, Mr. Hare, if you don't wish to file these submissions, that's fine. It's clear what you want. If you want to have at least the opportunity to be able to do that, you can get that opportunity. Mr. Kissoon will get the opportunity to respond. But as I said, it needs to be very short and succinct.
My lord, I would suggest. I mean, normally, we're not having written arguments. It's simply in light of what my lord has said about the court not having dealt with the question of interim costs before.
Yes.
We're very happy to file short submissions, and they will be very short submissions,
Yes.
on the court's jurisdiction and the approach of other courts on the question of interim costs, on the question of the suitability. I mean, I'm really not going to say anything. You heard the
Yes.
the appeal. I mean, it's your view, and that's a matter for the registrar. And in England, for a long time, with legal aid matters, you were obliged to go to where they had a similar thing, where the court would have the registrar would have regard to X, Y, Z. You used to ask for a certificate. So, and you do it on interlocutory hearings. You'd say, can I have a certificate for counsel? In other words, the judge who has heard the case certifies that this matter is suitable for counsel and not just a solicitor to attend on an interlocutory matter. And where two counsel have attended, you ask for a certificate fit for two counsel. You ask for a certificate fit for leading counsel. The idea that you would have written submissions on the view of the tribunal as to whether he's heard too many lawyers or is novel to me. But certainly on the question of interim costs, I'm happy to do that. I can put it. I don't think I'm going to say any more than I have done on the question of the parts 18.10 and the complexity. And I'm not going to compare it with other cases. You've heard the case. The registrar will make the decision. And so what I would simply ask for, rather than a sequential battery of arguments coming from the lawyers, is simply perhaps a short date. And I'm happy with, to accommodate Mr. Kissoon's convenience as to when that date is, by which both sides shall file their 3 pages.
And may I say, counsel, that I entirely understand your position. However, out of regard for those who are not here, particularly our sister, without making submissions, I think you should indicate what your requests are.
Of course.
So that the bench can be apprised fully of what you're asking.
I will summarize them in page 1. Part of page 1.
Wonderful.
Excellent. Mr. Kissoon.
Your Honour, might we suggest then for the respondents to put their submissions in the 3-page within 7 days, for us to reply within 7 days, and then the court to rule as is needed? We would like an opportunity to reply to the submissions that are sent in, as opposed to a simultaneous exchange. And the 3 pages will be more than sufficient to address our cursory issues.
Well, if we're doing that, my lord, we're going to get into a battery, and I would make the submission, he would reply, and I would have a right of rejoinder. So you'd have three.
Your Honour, we would just simply invite the court to adopt the same process that was recently undertaken in the Eslyn David matter. As
you keep mentioning this, my lord. We keep hearing of this case, which has not been put before the court. This recent case, I've got no idea what my learned friend is talking about. The normal, where written submissions are filed sequentially. If I'm asked to put my argument in 3 pages, and my learned friend wants to respond to that 7 days after, I'm allowed a right of reply. I don't know what he's going to say, especially if he's going to introduce cases I've never heard of.
Okay, well, we don't want to make it too difficult. What could be done is that you both file these 3 pages, and well, depending on what my colleagues think, you could have both a reaction, but that would be a very short one, of 1 or 2 pages. That all has to happen in in a week, and another week, and we need that. So because we don't want this to grow out to another cause célèbre, if I may say so. So it should be all very succinct and to the point. But I think I will ask my colleagues if they would agree with 2 rounds. So next week, 3 pages, and a week later, 2 pages in reaction, and that would be it.
Fully agree, Mr. Chairman.
So you could live with that, Mr. Herr, Mr. Kissoon?
Certainly. Thank you.
Okay, so then we have to find a date where you can file your short remarks.
Well, if those remarks are to be by next Friday, by both sides.
Yes, that is what Friday.
That is the 4th of September.
4th of September.
And then the
9/11.
Yeah, and then we could do it on the 11th for any further comments in our 2-page response. I don't think we need to put the page numbers in this direction, and I think we're all clear as to what, first of all, what I've asked for, and second, what we have to do.
Yes.
Mr. Chairman, sorry, is Mr. Kissoon still with us? I get the impression that he's dropped out.
Well, it seems so.
Miss Vera is his junior. Mr. Kissoon
is waiting in the lobby, so I don't know who can receive him. Mr. Kissoon?
He needs to be
yes,
let
Ron,
in.
I apologize. But
he's on, but no video.
He's on?
I can see DK in the bottom bar on my screen, but I can't. We don't have the pleasure of seeing Mr. Kissoon's smiling face.
Forgive me, Your Honours. I can hear you, but sadly I can't put the video on. The bandwidth is restricted.
Okay, well, the point is that we can hear you and you can hear us. So
yes, Your Honour.
The idea is that you both file your remarks. Let me call them remarks. On the 4th of September, 3 pages, not more. If you wish, it could be less, but not more than 3. And then 11th of September, unfortunately, a new 9/11, where you can react on each other's remarks, but not more than 2 pages. Would that be all right, Mr. Kissoon?
Very well, Your Honours. We're most grateful.
Okay, so it is decided. Once we have that, we will be able, not sure if we can do that in this recess period, but we will try to do our best to get it done as quickly as possible.
Thank you.
And we then will give a decision or an opinion on in writing.
Thank you very much.
Great. Okay, well, thank you very much. I think this concludes the session.
Grateful, Your Honours. Be well.
Court is adjourned. Good afternoon. Good morning.
Good afternoon.